Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about something unfair in our criminal justice system, and that's with regards to theft or fraud from employers. And so what we're talking about here is situations where you have an employee and they might, for instance, be taking a little bit of money out of the till each day, or they might be taking product home, or they might, for instance, be finding a way to pad out their hours. So they worked from 8 till 4, and yet they get the system to think that they've worked from 8 till 4:15, so they're getting paid for that extra quarter hour each day. Now, this can add up over time, and it's often not detected right away. In fact, I think most thefts are not sort of readily detected, but it adds up. And so it can end up being thousands of dollars by the time somebody goes, wait a minute, what's going on here? Now, the courts treat this incredibly seriously. They treat this, basically, it's presumed that you're going to be going to jail over this, even when we're talking about fairly small amounts. And even where somebody might not go to jail, for instance, if they'd stolen that money from a stranger. The court treats the relationship of employee to employer as sort of a special relationship. They note that it's a position of trust. Now, in some cases, position of trust makes sense. If you've got somebody who's an accountant or, a lawyer or, police officer or something like that, where they've got some sort of authority. I'm not sure how much it makes sense when we're talking about somebody who, for instance, works at a gas station or at Walmart or, wherever else. If you're working retail or if you're working food service, did you feel particularly trusted by your employer? Did you feel particularly, you know, probably not. So I don't know that that assumption really holds true in a big way, especially when we're talking about lots of the people who sort of get charged with these. But that's the law as it stands. And I'm going to refer to a case here. This is the case of the Queen, as it was at the time, and Song, which talks a little bit about the law about these kinds of offenses. And it notes, theft from an employer is a serious offense. The Alberta Court of Appeal has repeatedly emphasized that deterrence and denunciation are the preeminent principles used in sentencing for offenses where there has been a theft in a position of trust. In argument before me, counsel referred me to two cases which emphasize this very point, the Queen and Sareki and the Queen and Hatfield. In Sareki, and I hope I'm pronouncing that right, the accused, a 22-year-old with no prior record, stole $27,000 from the University of Alberta. Not a small amount. Alberta Business, School of Business Students Association. So, yeah. He was the vice president of finance for that association. He had no criminal record, and before his guilty plea, he had repaid the money he had stolen. At the provincial court level, he was given a conditional discharge. The Court of Appeal declared the sentence to be demonstrably unfit and substituted a 1-year conditional sentence order. Now, you might be wondering, what's the difference between those two things? They both have conditional in the term. Well, conditional discharge is a sentence that puts you on probation for a period. In this case, I'm not sure how long it was in that case, but if you complete that probation successfully, then the offense is discharged and you are not convicted. It just vanishes off your record. So it's a much more rehabilitative sentence because at the end of the day, somebody avoids a criminal record, which means that it doesn't end up interfering with future job prospects and other sorts of things. So a conditional discharge is a very good sentence for most offenses. A conditional sentence order, on the other hand, is usually house arrest, but what it involves is you are sentenced to a jail term, but you're going to serve it in the community. And so under conditions which can be strict and punitive, they might be 24-hour house arrest, they might be curfews, they can involve treatment, they can involve counseling, they can involve all sorts of things. And if you violate any of the terms of your conditional sentence order, you can be brought back in and they can do things like make your conditional sentence order worse, stricter. They can add time to it. They can also do what's called collapsing the conditional sentence order, which means that whatever time you've got left on it just turns into jail sentence, and then you go into custody. So a conditional sentence order is a much stricter penalty than a conditional discharge, although neither of them involves being actually in a jail cell. So the court said, absent truly exceptional circumstances, denunciation and deterrence demand a sentence of imprisonment for crimes of theft involving a breach of trust. Now, the court does consider a conditional sentence order to be a sentence of imprisonment, even though you're not actually physically in a jail. Occasionally, where truly exceptional circumstances exist, this court has upheld conditional sentences for this type of offense. No precedent from this court supports a conditional discharge as a fit sentence for this type of offense. In Hatfield, the accused defrauded her employer of $9,437.22 by using a company fuel and credit card for personal purposes, and by using her signing authority to give herself unauthorized advances. Ms. Hatfield pled guilty. At the time of the offense, she was in the process of ending an abusive marriage marred by domestic violence and threats. She was the sole caregiver to her 11-year-old son. At paragraph 3 of the decision, the Court of Appeal noted that Ms. Hatfield had since taken out a loan and repaid $7,000 of the money stolen. In provincial court, the sentencing judge imposed a 12-month CSO, conditional sentence order. The terms were relatively lenient. Ms. Hatfield had to perform 80 hours of community service and attend counseling. The Court of Appeal said the following: we agree with the Crown's submission that the sentence does not give sufficient emphasis to the objectives of denunciation and deterrence, and is therefore demonstrably unfit. We also agree that prior decisions of this court make clear that, absent exceptional circumstances, general deterrence requires a custodial sentence in cases of employee thefts. We are satisfied, however, taking into account the gravity of the offense, the particular circumstances of this offender, and the remorse demonstrated by her having substantially repaid the employer, that exceptional circumstances exist here. The Court of Appeal then imposed a 12-month CSO with curfew conditions for the entirety of the order. So that got a lot more strict, right? She was previously just to do 80 hours of community service. Now she's on a curfew for the entire order, and gave the accused no credit for the time she had already served on the original CSO. Since the original sentence was imposed on October 14th, 2014, the net effect was to increase the length of the sentence to 18 months. In both of the above cases, the court makes reference to exceptional circumstances. What does that term mean? The Court of Appeal has declined to precisely delineate what constitutes exceptional circumstances, but has said the following: there can be no catalog of truly exceptional circumstances. However, in the case of John, the court enumerated some possible examples at paragraph 239. One can always imagine circumstances of grave illness, stress, duress, small amounts of money, encouragement, and other bizarre circumstances, such as maybe mental problems, which would be exceptional circumstances that would justify a judge in not giving jail in a case of embezzlement or other theft by someone in a position of trust. They say, from the above, I take the following guidance. In cases of embezzlement, of theft, or theft in a position of trust, a jail sentence is required. In exceptional circumstances, a CSO may be a fit sentence. The Court of Appeal has said that there is no appellate authority for a discharge for this type of offense. So, this is, really, really serious. The court doesn't come out that seriously if you had stolen $10,000 from somebody you didn't know, or, taken a vehicle, which a vehicle can often have that kind of price tag on it. So this is not really where the unfairness is, right? It's not really super unfair that somebody might go to jail for stealing that amount of money from their employer. That's not what I'm saying is unfair. What's unfair is how they treat the reverse. Because if you've ever worked retail or, any sort of lots of jobs out there, there's lots of employers who are engaging in very similar behavior. For instance, they might insist that you clock out at 8 p.m. when the store closes. And once you clock out, they then insist that you wash the floors, which might take 30 minutes. And because you've clocked out, you're not getting paid. So you're effectively doing half an hour of work each day that you're not getting paid for because they made you clock out beforehand. Now, this is basically the same thing as the employee who finds a way to work or to, get credit, get time for an extra half hour each day. That employee is looking at jail. However, the employer, we don't typically, the courts don't typically view as being in a position of trust in the same way, notwithstanding the fact that the employer often is much more trusted in that sense than the employee is. The employee relies on the employer for things like, their safety while on the job, to ensure that they get paid, because the employee typically does work before they actually get paid, and for fairness in things like actually getting paid for all of the hours that they work. However, not only do we not view this as, a super aggravating circumstance in the same way that we do for when the employee steals from the employer, we typically actually view this as not a crime. And when I say not a crime, I don't mean not illegal. It just means not prosecuted criminally. So there might be, labor arbitration and labor boards that you can go to. There may be, civil suits that you can launch. But all of these things are very difficult. And in fact, a civil suit is usually going to be a big challenge. If your employer has ripped you off for, $9,000, well, it may not be worth the litigation at the end of the day, because hiring a lawyer and all of that may end up being more expensive than the money you recover, especially because it can sometimes be difficult to document that you were actually working for all that time. And your employer probably has better resources to fight you than you do to actually, challenge them on this. So the criminal justice system is normally something that can even the playing field, right? Because the government then funds the prosecution, not the person who is, the victim. But these are typically things that the criminal justice system just doesn't look at. Now, it wasn't always this way. In Canada, there was actually a crime of wage theft for a period. Now, it hasn't been there for a while, not within my lifetime. It was a crime from 1935 to 1955, and I'm not entirely sure why they got rid of it. But it seems kind of unfair when you look at it that, an employee who steals $50 out of the till is quite possibly looking at going to jail for that. Whereas an employer who decides, what, I am going to, somebody stole from the store. I'm going to deduct that from your wages, which in most places they're not allowed to do. And thereby deducts $50 from that employee's, wages, is just not a criminal offense at all. The unfairness here isn't in the sense of prosecuting thieves. It's that there's this whole category of people who seem to be engaging in fraud, that where we just don't prosecute them at all, and certainly not as seriously. So I think that this is something, I'm rarely the person who's like, we need more laws. That's not typically how I roll. My general philosophy is that we probably have too many things that are illegal, and there's a whole lot of things I would like to go through and just rip out of the criminal code entirely. But it seems really weird here that we prosecute one thing super seriously and the other thing not at all, when they can be the same offense, basically. I mean, when you're talking about messing with the time, the hours worked, that sounds like the same thing if the employee is adding, half an hour to their hours versus if the employer is deducting half an hour. I don't really see the difference there, and certainly not a difference where one should go to jail and the other is basically protected. So Let me know in the comments below what you think. I mean, this one might be a little more controversial than some of my takes, but, you know, that's why we have discussion. So let me know sort of what your thoughts are. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and Jane Babe and Luxor. And at the $20 level, Mark Haywire, Gerald to the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.